Debate around the exclusion of undocumented children from public schools is now before the courts. The South African Human Rights Commission has joined the Centre for Child Law as a friend of the court in a case where the centre is challenging the laws regulating the exclusion of undocumented children from accessing basic education. The Grahamstown High Court granted the Commission access to the matter. They were supported by the CCL. The application by the Centre for Child Law will be argued in the Grahamstown High Court in September. Iviwe Poti, our reporter, has more.
Well, a very important matter indeed, just in terms of how this matter of the Eastern Cape could also implicate or have an effect in terms of some of the national laws that South Africa has when we look at the right to education and the rights of scholar pupils or pupils of scholar going age. But we're going to speak to Mr. Gum of the Human Rights Commission. He's just going to tell us a bit more in terms of why was it important for the human rights to also join and be part of this specific case, and also maybe if we can also try to explain to our viewers at home just in terms of how important it is that we as South Africa seek to find clarity on issues affecting education.
Yeah, the right to basic education is a fundamental right. It's an immediately realizable right. And we are very concerned that learners are excluded from schools on the basis that they do not have the necessary documentation. This goes for South African learners without birth certificates, but also for foreign migrant learners who are in an irregular situation, don't have the necessary documentation. We have a lot of legal uncertainty because, for example, the admissions policy seems to suggest that there is a discretion on schools to accept and admit learners without documentation. We say it's not discretionary, it's mandatory. It also seems to suggest that learners can be excluded from schools after not obtaining the necessary documentation after a period of 3 months. We say that can never be the case. The Immigration Act also have provisions that are quite problematic. There are provisions that actually prohibit educational institutions from providing education to learners without documentation. Then there is another provision that actually seem to include these learners in terms of services that illegal foreigners have in terms of the Constitution and South African law in general. So what we are saying is that those services that are referred to in the Immigration Act, that it includes basic education, that is the provision that's applicable, and that the provisions that go against and even make it a criminal offense to provide for educational institutions to provide education, basic education to learners, that those provisions are not applicable to basic education, not applicable to children, not applicable to learners. It is a matter of national importance because a ruling in this regard here in the Grahamstown High Court will have implications both for the admissions policy as well as the Immigration Act as such. Another very important aspect I think I should highlight is that the head of education in the Eastern Cape has issued a directive, circular, whatever you want to call it, indicating that the post-provisioning of schools as well as school nutrition would be based on the number of learners that have valid IDs, passports or permits, in other words, documentation. This might be very detrimental to learners without documentation because schools are actually encouraged to exclude them in a sense, yeah. But on the other hand, schools who are embracing them and are allowing them to join schools and to enroll these learners, in those instances, also learners with documentation would be detrimentally affected because you would have a school with, let's say, 500 learners and not enough teachers for those learners, or school nutrition but not enough, and it will have to be shared. So we say that is clearly unconstitutional, and therefore we're joining this application. We're very happy that the court has ruled today that the South African Human Rights Commission, with what it can contribute to this case, has been admitted today as an amicus curiae friend of the court in this very important matter of national importance.
And then just lastly, just in terms of the 37 pupils that we speak of or that are in question, are these pupils now back at school and just going forward, will they remain at school throughout this process?
Yes, after the Constitutional Court intervened on the 15th of February 2019 this year, they have been admitted to schools pending the outcome of this very important matter coming up soon in September, we understand.
Mr. Khem, thank you so much.
Thank you very much.
Well, there we have it. This case, as we've already said, is very important and will play a pivotal role going forward in terms of South Africa and the understanding of the rule of law when we speak of this right to education, but also looking at the implications of the ripple effect that these rules might have in terms of the schooling environment for each and every child that seeks to have education in South Africa. But for now, it's back to you in studio.